Well, hello everyone. Hope you're having a great day. So I saw Meme Copium was discussing this topic about whether AI art is theft or large language models are theft, whether it's art, book creation, song creation, right? Whatever. It doesn't really matter whether it's theft or not. And I thought I would like to discuss this issue. So I thought I'd pop on real fast and talk about this because I think it's interesting. So, of course, we're going to be focusing on US law because that's the law I know best. Your mileage will vary substantially depending on what law you're in. The fair use considerations change quite a lot from other countries. Some countries don't really have fair use at all. For example, Japan doesn't really have a concept of fair use. For example, the UK has this more narrow concept, which they don't call it fair use. They call it like fairness in trade and dealing or something. They have a slightly different phrase for it, I think, but whatever. But they have like a more narrow concept. I think the US concept is one of the wider concepts in the law on fair use of this in the world. I'm not sure I could swear to it, but I think it's probably one of the wider ones. So we're going to analyze this from a US law perspective. And of course, to do that, let's start with 17 USC 107, because of course, that's a pretty reasonable place to get started. Now, it's worth noting, or at least interesting to me, that fair use started as a judicially created concept. It started as case law. The courts were faced with the position about, like, what do we do, right? The copyright law didn't used to have fair use explicitly said it, but we do have a First Amendment, right? So copyright and First Amendment are potentially in some tension because you have the idea of like the copyright is to the particular expression of an idea. That's the nature of what a copyright is to the particular expression. And then of course, First Amendment is also to the nature of the particular expression, right? So there's a bit of a tension. So the courts initially created the concept of fair use, and then later it was codified by Congress using basically the same parameters the court had created, which now the courts just use the statute. But this is the fair use section. And so basically it says when it comes to copyright issues, we talk about the fair use of a copyrighted work, including by reproduction, and then it has some purposes that we might do this for, purposes such as criticism, commentary, news reporting, teaching, scholarship, or research. These are non-exclusive, by the way, is not an infringement of copyright. Okay, so it is an affirmative defense, but it's not an infringement of copyright. Okay. And then it has this wonderful clause here in determining whether use made of a work in a particular case is fair use, the factors to be considered shall include. Now, please note these are not exclusive factors. Now, you will be hard pressed to find many cases, although if you look hard enough, you will find cases that talk about things beyond these four factors. But the courts have interpreted this clause as shall include as being like, well, these are the four factors you have to consider. But there might be other secret factors that we're not going to tell you about. And so occasionally you will find courts discussing other secret factors, although not often. So we have this four-part test. We start with the purpose and character of the use, including whether such use is of commercial nature or non-profit educational purposes. So here we're talking to the purpose and character of how I'm using the work as the work, right? Is the work itself commercial, or is it more in a non-profit sense? Or is it more in like an educational sense? And it's the nature of the work, or the purpose of the work, or the purpose of the use of the work, right? Am I using it commercially for business, or am I using it for teaching? Okay, that's kind of the first delineation. The second one is the nature of the copyright work. Here by nature, we mean the degree to which it's fact versus a creation of fantasy. So if you have a purely factual work, say for example, the telephone book is sort of the classic example, or a map, right? You can't copyright facts. So you can copyright the particular expression of the facts, but you can't copyright the facts themselves. So you can't, for example, copyright where various cities are. You can't copyright like names in a telephone book, but you can copyright how they're presented. And if you've ever looked at a telephone book, you'll know that they can be sorted in various ways with different fonts and, different headings and, different ways of representing the data. And you have the idea of like white pages, blue pages, yellow pages for different purposes. So you have things that are more on the pure fact continuum, telephone book, maybe a map. And then you have works of pure creativity, like, for example, Harry Potter. And then, of course, you could be potentially somewhere in between. For example, like a biography might be somewhere in between. Like it's a factual work, but with creative expression in it. So we're trying to figure out the degree to which it's factual, the degree to which it's a factual work, or the degree to which it's a fantastical work. If it is a factual work or a purely factual work, sometimes you'll hear attorneys say that the copyright is thin. They talk about the concept of a thin copyright. And what they mean is you have protection, but not very much, right? It's very thin because you don't have protection to the underlying facts. So all you have protection to is the expression. And depending on the nature of that, that can be not much. So, there's that. All right. So then also we have factor 3, the amount and substantiality of the portion of the use in relation to the copyright work. So how much of the underlying work am I using? This, of course, is a factor. There is not as though if I use 100% of the work, I'm necessarily infringing, nor is it necessarily the case if I use only a little bit of the work, am I not? In copyright law, we have the concept of the heart of the work that you'll see some of the cases of law talk about. So if you're copying the heart of the work, the most important part of the work, the fact that you're only copying part of it may be basically effectively the same as copying the whole thing because you're copying the heart of the work. So you'll see cases like that. So it might be the case that you're only borrowing a paragraph, but if it's the most important paragraph, that might be a problem. And if you're literally copying the entire thing, it might not be because it's a factor. And then we have the idea of the effect upon the potential use of the market of the copyrighted work. Now, this one is a little tricky to express because you have to analyze it as a market substitute, but you have to understand what exactly a market substitute is. Okay? And this can get a little tricky to explain. So a market substitute in the purest sense of it is I am producing a product that is the same as the product you are producing, and I'm selling it and enticing people to buy it in lieu of your product. But it is not a product that merely displaces your product, even if it takes a lot from it. So one could, like, for example, I don't know what example you might pick, but let's pick Weird Al Yankovic, just as a weird example, because it's the first thing that came to mind. Okay. Now, Weird Al Yankovic gets permission for his parodies, so we don't really have to do a fair use analysis when it comes to Weird Al, because he just gets permission. But for the purpose of illustrating it, let's just use a Weird Al example. Like if you believe that his parodies are true parodies, then if people prefer the parody song to the original, that would not be considered a impact on the market of the original. Okay? Because if this would be analogous, I don't know what the analogy would be. Maybe a new car brand. Okay, maybe that works. Let's suppose a new car brand comes along. Someone establishes a new car company, and people really like this car company, and people start buying from this car company. And let's say Toyota is sad, because people aren't buying as many Toyotas anymore. And they're like, well, that's not fair because they're displacing the market. Okay, now we'd be talking more patent than copyright in the automobile example, but let's press on anyway. If we were looking at this new car company, we would be asking, well, is it because they, basically just copied, they just took a Xerox machine and copy pasted Toyota? Is that what they're doing? Or did they just produce cars that potentially are vastly different than Toyota, but people just like them better? So what is the nature of the substitution, right? Is it because they are producing the Xerox copy, or is it because they produced a product that is different that people just prefer? One is fair competition and one is not. And the idea of fair competition in patent law also is relevant in copyright law because the legal fields tend to borrow from each other. So the copyright example versus patent example is perhaps more on point than you might know, because in legal analysis, you'll often see copyright analysis borrow from patent and patent borrow from copyright. It happens more than you might expect. So anyways, that's what they're talking about. And then, of course, they have this little caveat here at the end, and they say the fact that the work is unpublished, that's the work I'm borrowing from, is not a bar of finding fair use. So if I am taking something that you have not published yet and making fair use on that, I can still get to fair use. Now, it's going to be a little bit harder as a practical matter, right? The fact it's unpublished is basically a factor against, but it's not dispositive. There is no dispositive. There is no dispositive because these are factors to be applied, right? So I can't say, really, oh, it's this thing, because depending on other factors, it might not be that thing. Now, if like all the factors are going against you, that's a real problem. But, if you have even one factor in your favor and it's strong enough and powerful enough, maybe, which makes fair use analysis tricky. All right. So let's discuss the state of the law as it used to be like before a couple of years ago. So the courts have been interpreting this provision as they do. You can see here, for example, it was originally passed in 1976. The Copyright Act. Of course, as I mentioned, it was a judicially created concept before that, so it's not like it came into being in 1976. But the statutory provision came into being in 1976. So here's basically what happened. Long story short, the courts have been applying this four-factor test as they do. And what basically happened over the course of the next, 40 years or so, is that the courts gradually, but eventually somewhat conclusively, started leaning on transformative use as being the end-all be-all. They sort of went to the idea of how transformative it is, which kind of goes to this like fourth factor a little bit, and it goes to, the elements of the nature of the work a little bit, but it's like transformative became the thing. How transformative is it? The analogy here was basically, well, that's how human beings learn, because we are dealing with human beings, right? So, if you as a person went into a museum or like a bunch of museums, you're going to see art, and it will presumably inspire you, as one does. And then you will presumably take the art that you have seen in combination with your own style, and you will create your own art. Now, how original is that? Could be like you're just merely inspired by it, or you could like make something that looks more like a replica, right? So the idea of transformative is, how much did you basically distort the work? How recognizable is the work as the original? And this became the dominant factor. Automata for $10 says related. If something mechanically copies something when ingesting data, does it need to be reproduced copy in a fixed medium to trigger copyright? Sure. Yes, you do need it to be fixed. But remember what it means to be fixed. To be in a fixed medium just means it has to exist tangibly somewhere for any length of time. So if you have a computer that is creating this, the tangible medium can be the memory of the computer. The memory is tangible. It exists. You can touch it. And if you had the tools to look at the memory while the computer was running, you could see the ones and zeros. on the memory as they exist. So the memory is being written too, right? It is a writing that exists in memory. It might exist for a fleeting second, fleeting microsecond, but it is tangible. When they talk about something being tangible or written in a tangible medium, what they're trying to distinguish from is work that is never written down or otherwise never rendered permanent, right? So if I just am giving an impromptu speech purely off the cuff, and I'm not recording it or it's not based on notes or anything, right? If I'm just giving a purely impromptu speech, then that work is not copyrightable because it was never put into any sort of medium except the air itself. And that doesn't count, right? Because it's not written down. Waves are not being written, right? There's nothing that you can look at, see at, even in principle, to be able to see the thing. So yes, it has to exist in a tangible medium, but computer memory counts. All right, but it's a good question. All right. So anyways, transformative style. The Cartoon Network went the opposite way. Supreme Court saying the buffer was transitory despite the argument was written in memory. Okay, that's a reasonable point. Let's take a look at the Cartoon Network case and see whether or not I am incorrect. I always appreciate learning something new, or if I make a mistake of law, I'm always happy to correct it. Let's take a look. What is the site for the U.S. Supreme Court? I see a Second Circuit decision. Cartoon Networks versus CSC. Yeah, so I see a Second Circuit decision, but I don't see a merits decision from the U.S. Supreme Court. So the Second Circuit might have went the other way, but the Supreme Court didn't. But, it's still a point worthy of noting. So we'll read what the Second Circuit had to say, at least on the point, from Wikipedia. So Cartoon Network versus CSC was a Second Circuit decision regarding copyright infringement in the context of DVR operating by cable system. It's notable for distinguishing Ninth Circuit regarding whether momentary data is a copy. So Ninth Circuit says yes, and Second Circuit said no. Fair enough. In the case, Cablevision sought to implement a DVR system, allowing them to create copies of programs to be replayed. A consortium of copyright holders sued on the grounds that unlawful copying and public performance. Second Circuit ruled DVR did not constitute infringement. Okay, let's skip ahead to the Second Circuit ruling. Let's see. On the matter of temporary buffer copies of programs, the Second Circuit noted Copyright Act requires an alleged authorized copy to be fixed, meaning it had to be both embodied in a copy or phonorecord and perceivable for a period of more than transitory duration, which the court denoted as embodiment duration. The Second Circuit found district court had relied too heavy on the embodiment requirement to not properly consider duration. Hence, the Second Circuit rejected a lower court decision which did not address copies of files that only existed for a very brief duration of time. Okay, Cablevision copies were known to exist as long as 1.2 seconds, but the Circuit Court did not establish this duration of time as a boundary. This boundary remains undefined. So apparently there's some dispute on the Court of Appeals level on the issue. Noted. Thank you for that, bringing that to my attention. So there is some dispute on this on the Court of Appeals level. Ninth Circuit says it doesn't matter, and Second Circuit says 1.2 seconds isn't long enough, but without defining what's long enough, which is just super exciting. Okay, cool. Interesting. All right, so in any event, going back to this issue, the issue of whether it was transformative or not became sort of the game over 40 years. And then recently we got this opinion from the U.S. Supreme Court, Andy Warhol versus Goldsmith, which came out in 2023, which, long story short, revived or revivified the idea of commerciality as being a dominant aspect of the work. So the nature of the purpose and character of use, including commerciality, became a more important factor or was revivified as a factor. So now the Andy Warhol case at no point mentions AI or anything like it. It has nothing to do with AI on its own terms. But it's 2023 and the Supreme Court's not a complete idiot. So I think, or my working theory has been, although the case doesn't mention AI in any respect whatsoever, my working theory has been that the Supreme Court revivified the idea of commerciality as being a dominant factor because they were thinking ahead, at least partially, to the idea of AI, large language models, and similar. And so if you had asked me pre-2023 whether or not, Mid-Journey, for example, was fair use, I would have said yes. I think that Mid-Journey is often very transformative. You can get a work that doesn't really resemble any particular work, although it might have elements of it, but you can't really protect elements of a creation. You can only kind of protect the expression as a whole. You can't protect like sub pieces like that. You can sort of, but not really. So if you'd asked me pre-2023, I would have said, oh yeah, no, this is fair use. But after Andy Warhol, with the commerciality and revivifying, I am less confident in that because the Supreme Court seems to be suggesting or hinting or perhaps nudging or alluding to the idea that we should, when it comes to AI creation, consider the commerciality with enhanced seriousness. Now, what exactly does that mean? The Supreme Court, of course, doesn't say because they don't roll that way. But this is now, it seems to me, the dispute, right? The dispute is not really over the transformative nature. The dispute, although you can find, if you provide the right prompts, you can find direct infringement, although that's arguably on the person creating it, not the model, but whatever. But the issue is not really on the transformative nature, I don't think. I don't think that's really where the battle is. I think the battle is really on this commerciality aspect of it. And it's hard to deny that the AI models that are being created are not commercial and using the creations in commercial aspects by their own licensing terms. So is the Obama hope versus nope painting relevant? Sure. Yeah. Why not? I mean, that's just an exemplar of, it's kind of relevant, but also not really. I mean, that's just an example of when one court viewed whether or not something was sufficiently transformative or not and came to a conclusion as to a particular creation. So it is at best relevant as a point that one court thought when analyzing this question. But when I'm thinking about this on a more meta level, I'm thinking about this like at the Supreme Court level. I'm thinking about, of course, how the Supreme Court would view it, which of course would be informed by this one decision, but not controlled by it. But I think also the hope versus nope decision, if memory serves correctly, came up before the Andy Warhol decision in 2023. So the Supreme Court kind of threw everything up in the air, at least a little bit, in 2023. So pre-2023 copyright cases, which is, basically all of them, are certainly relevant, but are not as dispositive as they were before because the Supreme Court changed the balance of the analysis to look at commerciality. And it's not necessarily clear that all those pre-2023 decisions would necessarily have come out the same way if they were being interpreted through the Andy Warhol lens. So they're relevant, but no longer as controlling as they once were. The Supreme Court kind of threw everything up in the air. I went mute after all of them. Well, I don't know what to say about that. I didn't do anything. So, yeah. In the case of Mid-Journey draws outside the lines, yeah, fair enough. But the issue is not the transformative nature. That's not really the issue, at least not to me. And I think transformative is easy to win for Mid-Journey, in my humble opinion. There are some outlier cases to be sure, but if I were Mid-Journey, I wouldn't necessarily be freaked out about it. I can deal with the outlier stuff, fair enough as far as it goes. I'd be more freaked out about the things that threaten the model as a whole. right? If you can point to outliers where Midjourney or something else, created works that are infringing, fair enough, I suppose, but those are outliers, right? I'm partially concerned about the outliers because I might have liability for them, but I'm not as concerned about the outliers as I am about something that would upend the entire fundamental premises of the model, right? So the fact that they are revivifying commerciality is a more existential threat, at least it seems to me, with no clear answers, because of course the Supreme Court didn't give us any. So that is the bigger concern for me as Midjourney. As their lawyers, am I worried about Disney's recent lawsuit, where they showed how we infringe on Mickey? A little bit. Am I more concerned about where this is all going with commerciality? I'm more concerned. Disney is a problem. It's not the problem. It's not the problem. So that's my thought. So my answer to this question is, I think in the end, the Supreme Court, as they are wont to do, is probably going to try to have their cake and eat it too. One of the big problems here, though, is that the technology is developing so fast that by the time the Supreme Court finally decides to get involved, it's probably too late, right? I don't think they're going to do anything about this today. They're going to want to do what they normally do, is let things kind of percolate and pick it up in 5 years. That's kind of normally what they do. But and they might try to do something faster. But even if they did something faster, like even if they pick something up now, they're not going to provide any useful answers. They're going to kick the can down the road because of course they are. So they're going to want to try to solve this problem 5 years from now. But 5 years from now, well, we'll be on what? ChatGPT 9. And so, there's that. So it's a lot. So that's where things are going, and my best legal analysis at this time. And we will see how it develops. And yeah, I mean, it's going to be interesting. Of course, it's worthy of noting that other countries in the world, especially the EU, may come also and try to stamp on the party. But that is a little bit beyond my capabilities because I'm not an EU lawyer. I know enough to know that they're probably in more trouble in the EU. But beyond that, beyond knowing that they're probably in more trouble comparatively to the United States, I don't really have anything meaningful to offer here. So, yeah. I've been in the Midjourney office hours weekly. Dave's not focused on law. He's trying to serve his user base. I understand he's not focused on law. He's a creator of something that, why would he be? Why would he be focused on law? I mean, he is trying to create something that is a product, is a tool. And so one would imagine his focus is going to be on the tool because that's the nature of his work, right? So I don't blame him for being focused on, creating the tool. That's where his interests lie. Fair enough. My interests are law, less on creation of the tool. This is why we complement each other. And I'm sure to the extent that his lawyers are talking to him, I would imagine that they're saying things that are roughly comparable to what I'm saying. Now, they may assess the probabilities differently than me, fair enough. They may think that they're on softer ground or harder ground, particularly because their lawyers would be much more aware of internal information, of course, than I am. So they may know things from the clients that could potentially increase or more likely decrease their case, right? They probably don't know anything that makes their case better. They may know something that makes their case worse. So they may be in a different position to assess the risk probabilities. And even absent their inside knowledge, it's a little bit of guesswork because, I'm trying to say, how does this opinion read onto things, which is a little bit of guesswork. And you're trying to figure out what the courts are going to do, 5 years from now in an increasingly technologically rapidly changing domain. And courts by their nature are slow. They've always been slow. And so you're trying to predict how a slow moving thing is going to deal with a very fast moving thing. And so, but I'm sure their lawyers have contemplated many of these possibilities. And regardless of what they think internally, of course, would be pursuing their clients' best interests, which, of course, if I were Midjourney's lawyers, of course, I'd be screaming fair use until the cows come home as a dominant piece of my strategy. Not necessarily the only thing, but I'd be leaning on all that pre-2023 case law like it is going out of style. I mean, there isn't exactly a lot of post-2023 case law. So to the extent that they want to throw Warhol in my face, I'm like, well, I don't know exactly what it means. So I'm going to, cite the cases I can, which are all, of course, binding until overturned by the Supreme Court anyway, to the extent that they are circuit level decisions. So if I was Midjourney's lawyers, I'm going to scream fair use as a dominant aspect of my argument, for as long as I can. Is if I were a U.S. lawyer. If I were a lawyer, relative to the EU, I don't know what I'd do because I'm not specialized in that. So, but that would be my thought. But yes, the creators of Midjourney, the actual creators, probably should focus on the tool. That would be their job. The lawyers are there to help them, not get sued or at least win. So thank you, Ellen Parker, for the gift memberships. I would love to be a lawyer for Midjourney. I think or any of these models. I think that would be fun. It would be fun. It would be fun either way, actually. It would be fun either way. Probably the bigger challenge is in opposing the AI creation tools. But it's a very interesting legal fight either way. But I'd probably prefer to be on Midjourney or its competitor side of the equation. So maybe one of them will hire me and I will help them. If nothing else, I will buy them a lot of time, which may be good enough. If I can buy them a lot of time, given the development of the technology, that may just be good enough by itself. Maybe I don't have to win as their lawyer. Maybe I don't have to win. Maybe I just have to buy time. And that's the win. Could be. So it's, worthy of pursuing. So that's what I think about the whole thing. All right, guys, I'm going to sign off for now. I've enjoyed our little conversation. This has been fun. I'm going to go back to recording a video or something for daily, but I appreciate our discussion on these points. They're interesting developments in technology, and we will talk more soon. I've been Uncivil Law. Hope all is well. Cheers for now, my friends, and goodbye.